Ну что же, время начинать. Кто-нибудь из команды поддержки технической подскажите, как у нас с участником, видят они нас? Um, all right. Welcome and thank you for joining our seminar on international arbitration in Hong Kong. My name is Ilya Nikiforov, and I have a small role as a managing partner and leader of international arbitration practice of Yegorov Puginsky, the leading Russian law firm. To introduce Ace Lijanova, you may locate her on your screens. She will be moderating the event, and I will stand by to handle any question if there are any. To introduce ICE, she is not new to international arbitration and multi-jurisdictional dispute resolution. Her areas, besides international arbitration, is cross-border restructuring, insolvency, asset tracing, and recovery proceedings. ACE is also active, of course, in Russian courts, because many of the issues we handle have a touch not only beyond borders of the Russian Federation, but also have a role on the domestic scene. One of the top illustrious cases that will well characterize capacity of ICE is a case which has gained prominence in lawyers in The Lawyer publication, top 10 cases. It involved the Bank of St. Petersburg, one of the largest Russian banks. The value of the dispute was 500 million US dollars, and it had a stance beyond many other limbs. It had a stance in the High Court of Justice in the UK, where many issues were brought to light and became precedent-setting ruling judgment for the relative angle. Beyond and beside her pure legal job as a lawyer, I must say Ace is a graduate of Moscow State University. She is currently a PhD candidate. Her topic of her PhD is cross-border insolvency. Ice has also studied internationally in the University of Denver. And she is also a member of community projects of arbitration community. So not to take the time from the substance which you are craving for, I must say that international arbitration in Hong Kong is very much in the spotlight of Russian business and legal community, particularly because sanctions have very much closed traditional arbitration venues for many Russian parties. As you know, government sector represents 70% of Russian economy, and many of the most important Russian players are one way or another impacted by sanctions regime. So this will be, of course, one of the issues we discuss. So without further ado, I'm turning over to you. Please take over and steer our today's online discussion.
Thank you for such a warm introduction, Ilya Viktorovich. Good morning, dear participants of our today's webinar. Good afternoon to our speakers from Hong Kong. Let me start with introducing our speakers. Our first speaker is Ms. Victoria Handrimailo. She has a Russian background and she is a counsel at Hong Kong International Arbitration Center. I will refer the center as HKIC during the webinar. Victoria will give us an overview of arbitrating at HKIC, its statistics, rules, and competitive edge. The other speaker we have for today is Mr. Kwok Ki Chong, partner. He heads arbitration practice group at Deacons, a very well-regarded law firm based in Hong Kong. Kwok is going to talk about Hong Kong as an international arbitration venue, Hong Kong legal framework for international arbitration, and recent trends in arbitration there. We actually tried to make this event as interactive as possible, and for this reason, the format of today's webinar is like an interview where I'll be asking questions and our speakers will respond to these questions using their slides. Another interactive feature we have is that we will have a polling during the webinar. You'll see 7 questions popping up on your screens, and you are very welcome to reply to these questions in a yes or no format. And the results of the polling will be available to us in 2 minutes after you answer 2 questions. In the course of the webinar, you're also very welcome to leave your questions in a special Q&A section of our WebEx platform. You can find it in the left corner. You may type your questions in Russian. It's not a problem at all. I'll be translating them to our speakers, and we reserve 15 minutes for Q&A session after the presentations of our speakers. You may also play with your layout button in the upper right corner, and depending on your preference, choose your view options, stack or side by side. You can make the screen full screen format, or depending on what you prefer. And before our speakers start, I would like to make a few introductory remarks as to why we actually decided to organize the event on this topic. Well, it is well known, and it's not actually a secret that sanctions imposed by the United States and the European Union countries in relation to certain Russian individuals and legal entities, which are called SDNs. Since 2014, sanctions have had a substantial impact on international arbitration involving Russian parties. And I asked my colleague Dmitry here to start the polling, where you can see the first question, which is: have sanctions created difficulties for arbitrating in Europe, in your opinion? Why we concentrate on Europe here is because European arbitral institutions as LCIA, ICC were mostly traditionally preferred by Russian parties, and that's why we put Europe here, while American Arbitration Association, III, was not that popular among Russian users. So because of the sanctions, many practical issues may arise at various stages of arbitration. And we actually have had it in our practice when our clients faced some difficulties because of the sanctions during, for example, appointment of arbitrators, if they are European Union or American nationals, instructing legal counsel involving experts, participation of sanctioned persons as witnesses. And the main difficulty Russian users may have is payment of arbitration fees and expenses and costs, just because banks are likely to block or freeze any payments, whether where either the payee or the payer is a sanctioned entity. And this would actually lead to the possibility that payment in US dollars or euros of arbitration fees and costs can be blocked. Another issue is regarding arbitrators, for example. If the arbitral institution or arbitrators are domiciled in a jurisdiction that has imposed sanctions on a party to a dispute, these arbitrators or arbitral institution may be required to obtain a special license, allowing them to perform in their role during the arbitration proceedings. And for all the mentioned reasons, sanctions, external political pressure have resulted in decreased interest in going west, if I may say so, for many Russian businesses. And unsurprisingly, they are now increasingly looking towards neutral venues to resolve their disputes. And we see an increased demand of our clients for consultation, for legal advice regarding what forum, what jurisdiction should be now put in their arbitration clauses. Or, for example, in order to amend such arbitration clauses for the contracts to which parties have already entered, in which parties have already entered, there is such a request. The trend of Russian parties choosing neutral arbitral venues was actually has been reinforced in view of changes made to the Russian arbitrage procedure code, which came into force in June 2020. Let me see. Okay, so we have the outcome of the polling for the first question, and I can say here that, for example, if the contract was entered into in, let's say, 2015, 2016, etc., there is a possibility that the dispute has not arisen out of this contract. And if there will be disputes, then the issues that I mentioned could rise. I'm asking my colleague Dmitry to put the second question on your screens. Have sanctions affected your choice of arbitration institute and seat of arbitration? Again, it's a yes or no format. So I was talking about the recent amendments to the Russian Arbitrage Procedure Code, and one of the main consequences of such amendments is that any prorogation of arbitration agreement entered into by Russian sanctioned party and providing for arbitral forum or a seat of arbitration in a jurisdiction that actually adopted Russia-related sanctions can be potentially unforeseeable in Russia. And for this reason, we started to think of how we can deal with this risk, how we can actually minimize it. And our recommendation was that the arbitral institution and seat of arbitration should be in a jurisdiction that has not imposed Russia-related sanctions, that applicable law of the contract and law of arbitration cannot be the law of the country that imposed sanctions. And the last recommendation, the third one, is to administer an arbitration by a permanent arbitral institution recognized by the Russian Ministry of Justice, the one which has obtained a license for such activities. And if we look at what options we actually have right now is first of all Russian arbitral institutions. They are mostly preferred for simple domestic disputes, according to the statistics of these arbitration institutions. And the other option is European arbitral institutions, like I mentioned, but again, according to their statistics, we see that the entire caseload originated by Russian users declined from 10.3% to 6.6% in 2019. The third option is to choose a neutral arbitral institution like HKAC. Okay, Dmitry, do we have the second question on polling? I can see it. Okay, so after such introductory remarks on my side, I'm happy to pass the mic to our first speaker, Ms. Victoria Handrymyla, and I have a few questions to Victoria, and she will be able to answer to this question using PowerPoints. Okay, so Victoria, first of all, could you please give us a brief overview of HKAC, when it was founded, the structure of the institute, panel of arbitrators, regarding the, we may have questions regarding the rules, facilities, and where besides Hong Kong, the institution is represented. Thank you. And I remind to our participants that you are very welcome to ask questions in Q&A section of WebEx.
Good morning, everyone in Moscow, and good morning from Hong Kong. Just to double check, can you hear me well?
I personally can hear you absolutely all right.
Okay, so I think I may proceed, and given the time constraints, I will focus on the key points of HKC activities, and I will start with brief overview of what we do and who we are. So HKC has been founded in 1985. Last year we celebrated 35th anniversary of our existence, and so over this period we managed around 10,500 cases to date, and HKC is a non-profit institution, financially self-sufficient and free and independent from any influence or control. We are so-called one-stop shop, which means that we administer the arbitration, and we also handle the mediation, adjudication, and the domain name disputes. We are currently represented. We have three main offices. So our main office is based in Hong Kong, where our administration of all cases is conducted. In 2013, we opened our first overseas office in Seoul, and in 2015, we opened the office in Shanghai, and we were the first foreign arbitral institution which opened the presence in the mainland China. So with respect to the organizational structure, HKC has a very transparent structure in terms of organization, and at the top HKC is governed by the HKC Council. We can say so-called board of directors, which are represented by the dispute resolution practitioners and industry experts. We have both common law and civil law experts on all bodies which governs the HKC as well as Secretariat, and it's necessary to mention that one of the members of HKC Council which governs our policies is Professor Anton Asoskov. The other body of HKC is Executive Committee. It directs the activities of HKC based on the policies that Council adopts, and we have freestanding committee which names speak for themselves, and for the parties especially important to explain what are the proceedings and appointments committee we have. So the proceedings committee is the committee which deals with all procedural questions arising before HKC in our arbitrations, and the appointments committee deals with the appointments and costs of arbitration. The administration of our cases is dealt by the HKC Secretariat, which I'm a part of. I'm counsel at the Secretariat, and the Secretariat is led by the Secretary General Sarah Grimmer. So here you can see that we have individuals from around the world on our committees which decides the matters submitted to HKC. And this is our team from the Secretariat. And the next slide, I will briefly just mention that the market leading arbitration rules of HKC are HKC administered arbitration rules, which were first published in 2008 and amended twice in 2013 and 2018. So I will speak a little bit of its features later in my presentation. And with respect to the list and panel of arbitrators that we maintain, we have two panels of arbitrators. It's the general panel and the panel, special panel on financial disputes and the intellectual property dispute. And we also have the list of arbitrators. And in the list, there are arbitrators which have a bit less of experience than the arbitrators on the panel. And when HKC appoints an arbitrator in our cases, we usually consider the candidates from our HKC panel or list of arbitrators. And for example, today we have our colleague, Mr. Kwon Kwok Cheon, who is on HKC panel of arbitrators and who acts in our cases. I think this is the brief overview of what we do.
Yes, thank you, Victoria. Can I interrupt our interview for a second for an organizational issue? So there is a polling, like I mentioned, where you are welcome to answer in a yes or no format. And I see that 70% of our audience today have not voted, and we would be very grateful if you will be able to answer to our questions, just because thanks to your feedback, we will actually understand if the topic is of interest, and we will see if, for example, The question we just recently had was, do you have an experience arbitrating at HKIC? So depending on your answers, we'll be able to tailor our today's webinar to your needs. So please ask questions and please participate in our polling. Thank you. Another questions I have, and probably our participants may have in mind, is what is HKIC's statistics on, for example, Russia, for example, on cases originated by Russian users, and who the main users of HKIC? What is the trend in this sphere? Thank you.
Thank you, Ice. So with respect to the statistics that we have, can I just, yes. So this year we had a record statistic in respect of the overall cases, and especially in respect of the arbitration cases. So we passed 300 cases already last year, and this year we had 318 arbitration cases. And if we look at the trend that we have in our cases, we see that the parties tend to prefer the administered arbitration from year to year. And if we look at the industry, meaning that from what actually disputes the arbitration arose, the main remains the sale of goods contracts. We also have maritime and corporate. This year they are in equal percentage of the disputes. And if we look at the nationalities of the parties, so the main users of HKC are parties from Hong Kong, mainland China, BVI, and others, as you see on the slide. And with respect to this, I would like to mention that HKC has a special expertise in China-related disputes, because the companies and the entities individual from the mainland China remain the top users for HKC disputes. And we also have if we count the percentage of international cases we have, meaning under international, I mean that at least one party in the cases is not from Hong Kong. And this year we had 70.3% of the cases. And we also, if we look at what is the seat of arbitration in our cases, it's mostly Hong Kong. And also the governing law of in the contracts that we see, it's the Hong Kong English PRC law, and we also see the 12 other different governing laws in the contracts. Our cases are mostly conducted in English and or Chinese. We also have bilingual cases, given that we have the case managers on the secretariat which are able to conduct the bilingual cases. And the total amount of dispute this year we had in all our cases is $8.8 billion. And with respect, so let me quickly check. I will briefly mention the statistics with respect to the Russian parties, because I think that's what the Russian users are interested in. So first, I would like to mention that since 2009, we handle 23 Russia-related cases, and the highest number was in 2019. And this year, we can say that we see the growing demand, because already this year we have received already 3 cases, and from all these 3 cases, one case is seated in Russia. With the seat there, and we also see in the Russia-related disputes that the parties put the English law as the law of their contracts. The spheres that the disputes arise are mainly commercial, maritime, and corporate. The total amount of disputes so far for the 23 cases is $418 million US, and you can see that the lowest amount in dispute was 50,000 US, which is also a very good sign, which means that because the arbitral institution should remain available not only for the high-stake disputes, but also for the medium-sized companies which are still interested in the neutral dispute resolution forum in arbitration. With respect to the languages, so the mainly, under languages I mean the languages of the contract, because all the arbitrations that we had with Russian parties were conducted in English. The languages of the contract were in English, Chinese, or Russian. The nationalities of counterparties were Chinese, Hong Kong, and European, and what we see that mostly claimants were Russian parties. And with respect to the, if I may briefly mentioned what the competitive age of HKC in general, not respect, I think I will speak a bit later about our permanent arbitral institution status, but in general, I think that the key features that I have time to cover today, it's first that HKC has a special expertise in relation to the China related disputes, and in this regard I would like to mention the arrangement that came into force between the Hong Kong government and the Supreme People's Court of China, which allows the parties where with the seat in Hong Kong to apply to the PRC courts for the interim measures in respect of the arbitration seated in Hong Kong and administered by one of the authorized arbitral institutions, which includes HKC. And we consider this as a groundbreaking development with respect to the China-related cases with the seat of Hong Kong, because before the parties could, if the seat is before, if the party applies to the court in the PRC in support for interim measures in support of the arbitral proceedings, it was only able to get the interim measures if the seat was in mainland China. Now that it expands the coverage, and now it also covers the arbitration that are seated in Hong Kong. And we see this mechanism in practice, and so far when this arrangement came into force in 2019, we handled 42 applications, because what HKC does, HKC issues the certificate to the PRC court, which confirms that there is an arbitration initiated with HKC, and based on that, the party is seated in Hong Kong. Based on that, the party is able to apply with to PRC court for the interim measures. And the applications that were successful, they are in different nature. They with respect to the preservation of assets, evidence of conduct, and the amount of the application with respect to the preservation of assets worth around $2 billion US, and the overall court, at least what we are aware of the amount that court ordered, is around 1.6 billion US. And also one thing that I would like to mention with respect to the HKC rules as our feature is that I already said that our most recent version of the rules is 2018, and it addresses the questions of the complex arbitration with the multi-party, which is very important for the users, especially in respect of the consolidation, or if the parties want to have the arbitration on the expedited basis, they are able to do so under HKC rules. And it's interesting to mention 2 points. The first one, that when HKC amended its rules in 2018, of course, nobody could predict the COVID situation. However, at that time, we already introduced the provision which says that the arbitral tribunal is encouraged to use the technology in their disputes, and this provision is currently used in arbitrations, especially given the COVID situation in the world. And one more thing that I will briefly mention is the fees that the mechanism that we already introduced in our first version of HKC administered arbitration rules in 2018, and which still is there. So we were the first institution that allowed the parties to choose how they want how they want the arbitral tribunal to be charged for the services, and this is either on hourly rate basis, on the basis of the amount in dispute. And this is very important because this allows the parties to predict what costs of arbitration they can incur in their proceedings. So I guess that's...
Thank you very much, Victoria. Well, first of all, thank you for your comment regarding statistics, because, well, I personally see it's very impressive that during the first quarter of 2021, you have 3 cases already originated by Russian parties. It actually confirms the approach that I mentioned, that the Russian users are increasingly looking for neutral jurisdictions for their disputes. And you also mentioned that the highest number of Russian cases was 2019. And I'll ask you to cover the issue of the license obtained by HKC to operate the disputes in Russia. And I think that it's not a coincidence. It's probably the consequence actually of obtaining such license. And for our users, for our participants, I'd also like to draw your attention that Victoria mentioned that there were arbitrations where seat of arbitration was Russia, I presume Moscow or St. Petersburg. So I just wanted to underline the fact that in your arbitration agreements, especially probably the pandemic may have the may have become a concern for some parties. So it is absolutely possible to choose Russian cities, locations as seat of arbitration. So for your dispute, for example, to have HKC rules applied and at the same time have a Russian seat of arbitration. But as Victoria mentioned, there are features which actually help a lot to parties where seat of arbitration is Hong Kong. Like Victoria mentioned, support of Chinese courts, and we will also ask Kwok about the approach of Hong Kong-based courts regarding the arbitration. So we'll definitely cover this issue later. I would also like to ask you, Dmitry, can we have a polling with the fifth question, which is, are you familiar with HKC arbitration rules? While Victoria will be addressing the issue of the license to operate on the territory of the Russian Federation, I kindly ask you to respond to this question in a yes or no format. Okay, so yes, it's very well expected question. And we all know that in 2019, HKC became the first foreign arbitral institution to be granted permission to function as a permanent arbitral institution, as we call it in Russia. Victoria, how Russian parties may actually benefit from it? What opportunities obtainment of such status has opened to HKC? Thank you.
Thank you, Ice. And I will just give a brief remark to the seat that, as you correctly outlined, the seat could be either considered by parties or Russia or Hong Kong, and each seat has its own features. But especially with respect to the seat in Russia, with the recent amendments in law, some disputes can be seated only in Russia, and the additional requirement to such category of disputes to be administered by the permanent arbitral institution. And in such situation where HKC got the permanent arbitral institution, the parties has a wider choice to consider what actually institution they want to provide in their arbitration clause. And with respect to our license in 2019, I also wanted to mention that in 2020, HKC and also VIAC, Vienna International Arbitration Center, submitted the joint request for clarification on interpretation of the Russian arbitration legislation with respect to the specifics of the permanent arbitral status. And in May, the working group responded, and I encourage actually everyone to read this document, because this document is a very of practical nature to understand how the PIA status is relevant to the disputes in respect of which the parties may initiate the arbitration. And with regarding the advantages of the PIA status and the HKC PIA status, what actually it brings. So first, I wanted to mention that if the arbitration is administered by the permanent arbitral institution seated in Russia, the parties are allowed to waive certain forms of Russian court supervision and interference, under which I mean the setting aside power of the court at the seat in Russia, or for example, the court order to rule on the tribunal jurisdiction as if there is an interim award on the tribunal jurisdiction. And actually the case we which is seated in Russia, the parties waived in their agreement the supervision of the Russian court. So we can see that the parties use this mechanism in practice. Also, with respect to the if the case is administered by the permanent arbitral institution and the parties are able to get the assistance from the Russian court in taking the evidence. Also, if there is an ad hoc arbitration seated in Russia, what the law provides, it impose that only the permanent arbitral institution can act as a appointing authority in the ad hoc arbitration seated in Russia and provide the other assistance to such ad hoc arbitration. It could be the management of the deposits and other matters arising in the arbitration. Also, the big pile of the cases and the big question is the Russian corporate disputes. Under the Russian corporate disputes, I mean the disputes within the meaning of under the meaning of the Russian law, what does the corporate dispute mean? It's relating to the establishment management of a legal entity which is incorporated in Russia. And such disputes can only be administered by the permanent arbitral institution, which gives the which imposes the imposes additional requirements in the arbitration clause. It could be also some dispute can be only administered under special corporate dispute rules. And with respect to this, so far HKC hasn't adopted such. And we've also, it's worth mentioning the procurement disputes. So the disputes which are the contracts which are concluded by Russian commercial companies controlled by Russian state. They are arbitral if they are seated in Russia and administered by the permanent arbitral institution. And with respect to the domestic disputes, generally domestic dispute can be administered by a permanent arbitral institution only if it has a representation at the territory of Russian Federation. So currently HKC doesn't have such doesn't have such a subdivision, and there is an exception with such a requirement that it is the disputes between the participants of the special administrative region. I think I see a question. Oh no. No.
Yes, there is a question in a chat. Can you see it?
Yes. Thank you, Ilya. So the question is it correct for that for arbitration with HKC, with the seat of arbitration in Russia, we can get the interim measures from the PRC court? So let me clarify that the PRC interim measures from the PRC court also only available to the arbitration seated in Hong Kong. So this is restricted to the Hong Kong. Before, there was not even that possibility. So before, courts only in PRC courts can only issue interim measures for arbitration seated within China. Now they expanded abroad and it is limited to the Hong Kong.
Thank you.
I think that's what I wanted to cover as with respect to the our status.
Yeah, great. Thank you. Thank you very much, Victoria, for this detailed answer. And we have some time to be spent with you. And I ask you to briefly, please, provide us with a recommendation on drafting HKC arbitration clause. So could you please help our users? As I see from the polling, there are only 3 participants who said that they are familiar with HKC arbitration rules. So if you can provide your guidance, that would be great. Thank you.
Thank you. I think my answer to the question might seem trivial. However, this is the paradox that we have lots of experienced arbitration practitioners from all over the world. However, we still see in our cases pathological arbitration clause, and the parties spend lots of monies in struggling to interpret what the parties means. So I think my suggestion will be don't not to wait till the last minute to draft the arbitration clause in the contract, because especially with respect to the Russia-related disputes, with this big section of the legislation with the requirements, actually what the SID should be, what the rules should apply. I'm talking about, for example, special corporate disputes rules, and what institution can administer, meaning whether it shall have a status of a permanent arbitral institution or not. And as I said, I encourage to read the working group answer to the HKCDAC request for interpretation. It's not binding on the Russian courts, but it still gives a very good guidance for the permanent arbitral institution specific. And also, I maybe sound trivial that I encourage you to read the rules, the HKC administered arbitration rules, before providing them into the arbitration clause, because by this the parties can see the extent that they can deviate in their agreement. And now also, of course, we recommend as the basis to use our HKC model clause. However, especially with the Russia related disputes, it has the specifics which shall be thoroughly studied in advance in order to even for the questions how the disputes can evolve, what elements it can include, and whether it will be covered by, for example, by the requirement under the law or not. So that will be my suggestion.
Thank you, Victoria. And I did mention this question just because I completely agree with you. We do have projects where clients suffer from incorrect arbitration clauses. I just said that it's very important to demonstrate our users, our participants, what is the best way to draft the arbitration clause in their contracts if they desire to put HKC and as an arbitration institution and Hong Kong as a jurisdiction for such disputes. The last question I have, and I think that this question is of practical interest to our today's participants, is the statistics regarding the enforcement of HKC arbitral awards in Russia or by Russian parties, for example, in Hong Kong. Is this statistic available to you? Do you have any information regarding this one? Thank you.
Thank you, Ais. Yeah, unfortunately, we don't keep the record of the statistics of HKC awards in Russia. I'm not able to provide this information. I will just tell, for example, in respect to the enforcement in the mainland. China, and we do, as I already mentioned, we do lots of cases with those parties for 20 years. We are aware of only 3 awards that have not been in HKC awards that have not been enforced, and the reasons of the non-enforcement of all of those awards were not related to the administration by HKC of arbitration, but were rather related to that the ruling of the tribunal was outside the scope of the arbitration agreement or some other matters. And with respect to the enforcement in Hong Kong, I think it will be covered by Kwok how what the approach of the Hong Kong courts and how the pro-arbitration the approach is.
Okay, thank you. Regarding the statistics here in Russia, I as a local practitioner can add on this issue and say that yes, there are cases on recognition of HKC arbitral awards. Like Victoria mentioned, the statistics for the cases is growing, and accordingly, the statistics of recognition here, arbitral awards here in Russia is quite low just because of the volume of the cases. But I think that in the near future we'll be able to see the growing number of such cases. Okay, Victoria, thank you so much for your detailed presentation. I appreciate that you are with us today, and if there are questions which have not been covered by Victoria that you may have, please do ask questions in your Q&A section in the right corner of our platform, WebEx. And I'm happy to ask questions regarding Hong Kong as a venue for international arbitration, and I'm happy to finally involve Kwok to our discussion. So Hong Kong, it's well known that Hong Kong is obviously one of the leading commercial hubs for international business transactions. But what does Hong Kong represent as an arbitral venue? And what makes Hong Kong an attractive jurisdiction for Russian disputes? Well, we did mention that the neutrality can be one of the main factors, and I asked my colleague Dmitry to put this question on your screens. Question 6, do you consider Hong Kong as a neutral, non-biased jurisdiction? Again, yes or no format. So yeah, I'm addressing these questions to Kwok and would be grateful for his response on it. Thank you.
Thanks, Ice, for asking the question, and good afternoon, everybody, and thanks for EPAM for organizing this webinar, and also thanks to the audience from Russia. So Hong Kong, I think we have many advantages as a venue for arbitration. And let me see whether I can put my PowerPoint in answering your question here. Yes, there are many advantages. Let me start with the convenience of location for doing arbitration in Hong Kong. Now, first of all, traveling from Moscow to Hong Kong, I checked it from the internet. It takes about 12 to 13 hours by plane. So it's not so far away from Moscow comparing with other arbitration centers in Asia. So in addition, Hong Kong is a small place, and usually your arbitration will take place in Central. That is the place where our Central Business District is located. And you can travel from the Hong Kong airport to HKAC in Central by 24 minutes from the airport to IAC. So it's quite convenient, first of all, to do arbitration in Hong Kong. And then what about accommodation? Now, here I set a parameter. There are at least 15 hotels of various grades, from 3-star to 5-star, within 15 minutes walking distance from HIAC. You can see the familiar names here from this slide, like Four Seasons, Shangri-La, Conrad, Marriott, and other hotels. So accommodation is not a problem, and they are not so expensive compared with other places in Asia or in Europe. So first of all, location is convenient in Hong Kong for doing arbitration. And also, Hong Kong is a safe place, and you can walk in the evening, in the morning, in Hong Kong anywhere without worrying your safety here in Hong Kong. Also, as Ice has mentioned, neutrality is important in conducting arbitration. Now, of course, Hong Kong is part of China, but it is a special administrative region. That means we have one country, two systems regime implemented in Hong Kong. We have a different legal system. Hong Kong administer common law rather than civil law like mainland China. And although it is common law, and the US or EU sanction is not part of the Hong Kong law, so we don't impose sanctions on Russian parties here. This is important. And also, even if your counterparty is from mainland China, and you may think, well, they are from mainland China, they may have an edge over you. That does not happen to my experience, because we have an independent legal system, which is quite different from that in mainland China. And also, arbitration enjoys great support from the Hong Kong law. This is the Hong Kong framework for international arbitration, and the provisions are contained in arbitration ordinance. We adopted the ancestral model law in Hong Kong. As I understand it, Russia also adopted the ancestral model law in the international commercial arbitration law. That means Russian parties, you won't be unfamiliar with the rules and procedures of doing arbitration in Hong Kong. And excellent legal support, I mean, there are many aspects of support from the Hong Kong court. For example, if one party failed to appoint the arbitrator, then the Hong Kong court can assist. And the provision in Hong Kong is that if one party failed to appoint his arbitrator within 30 days of the request for appointing arbitrator, then the HKIAC can step in and can appoint the arbitrator from the party. Or if there's no agreement between the parties about how to appoint an arbitrator, then HKIAC will also appoint for the parties. And the other example where the court may assist in the arbitration is the challenge of arbitrators. For example, some parties they might challenge the appointment of arbitrators by saying that he or she is lacking the jurisdiction to adjudicate the dispute between the parties, or one party may say there's apparent bias by one or some of the arbitrators in the tribunal, or some arbitrators he or she may lack of the qualification. Then either under the IAC administered arbitration rules or the other set of rules, they may deal with such challenge. If not, then the court may assist in dealing with such challenge of the arbitrators. And also, as mentioned by Victoria, the court will grant interim injunction to the parties before the issue of the award. This is very useful. This is in aid of arbitration, because even if you win in the arbitration, if there's no asset for you to enforce, then it is only an empty award. It is maybe a very long award, very beautiful written document, but then it does not help you to get the asset in enforcing the award if the court does not assist you. And interim injunction, here I have an example, what we call a Marijuana Injunction. Basically, the name Marijuana, it comes from a case in England. It refers to the type of injunction where the court will freeze all the assets of the respondent worldwide. So the assets will be there, and after you have obtained your award, you can enforce the award by getting to the assets frozen under the Marijuana Injunction. Now, Victoria has explained in detail the persuasive measures we can obtain in mainland China, and if with the assistance of the HKAC, you apply for this persuasive measure, then you can have an interim persuasive measure in mainland China. I think this is the only Hong Kong is unique in such a facility, because otherwise, if the seat of arbitration is not in mainland China, there's no way you can apply for such persuasive measures. But Hong Kong is an exception. Now, also after obtaining the award, you can enforce it through the court. And Hong Kong, we have a speedy enforcement in court. In my experience, the quickest application for enforcement, which was approved by the court, is within a few days of application. So you can see it is very efficient. And also, Hong Kong is a member state to the New York Convention for reciprocal recognition and enforcement of arbitral awards through the accession to the convention by China. And under the New York Convention, we have 168 member states, such as USA, UK, Japan, and of course Russia. So foreign arbitral awards, you can enforce it quite easily in Hong Kong. And because Hong Kong and mainland China we are within one country, so we cannot use the New York Convention for enforcement of award. Then we have a separate arrangement between the government of mainland China and Hong Kong. Under this arrangement, mainland award can easily be enforced in Hong Kong and vice versa. Now, in recent years, we also implement some measures to facilitate arbitration in Hong Kong. The first one is third-party funding. Traditionally, under common law, maintenance and trumpery is not allowed. It means that you cannot finance an arbitration or litigation in Hong Kong where you have no legitimate interest. And also, you cannot enter into a conditional fee arrangement with anybody. The paying of fees to your lawyers, which depend on the outcome of the litigation of arbitration. However, under this third-party funding arrangement, which is now quite common in the UK, you can get to some financial institution. If they agree, then you can borrow funds from them to finance your arbitration in Hong Kong. That will be legal since 1st of February 2009. So it's quite a breakthrough to enable easier access to the parties for arbitration to resolve their dispute. And another thing Hong Kong is considering is to make conditional fee arrangement legal. That's still under public consultation, which ended on 16th of March 2021. And we still have to see at what time the legislation can go through in Hong Kong.
Great, thank you, Kwok. Well, it's actually great to hear that Hong Kong legal and court system are so supportive of arbitration. of course, it is a great advantage of Hong Kong as a venue for international arbitration for Russian parties. And of course, as we all understand, the ability to obtain interim relief prior or during the arbitration is a great opportunity. And if, for example, our participants are used to injunctions provided by English court during LCIA arbitrations, like Kwok mentioned, Marijuana Injunction, they all can be obtained in Hong Kong courts. So the and this is a great advantage as well from what I heard from Kwok. Okay, and I think that one of the concerns Russian parties may have here is that in 2019 we all became aware of civil disturbance in Hong Kong. And some people may think that it has somehow affected the attractiveness of Hong Kong as an arbitration venue. So what is the current situation, and do you see that it has been or still is an obstacle to hold international arbitration there in Hong Kong? Thank you, Kwok.
Thank you. I got a picture here. You can see from this slide, this is the protest you are talking about. But I think it's now a matter of past. Particularly, such type of protests exists since July 2020. I think one of the reasons for the ceasing of this protest is the coming of COVID-19. People, they are quite worried to gather together to get the disease. And so later, we will talk about the national security law, and also that might also be one factor which why there's no such protest any longer in Hong Kong. Now, coming back to COVID-19, of course, it causes inconvenience to everybody in the world. And if you come to Hong Kong, we have quarantine requirements. For Russia, I have checked, you have to be quarantined for 21 days in hotel before you can do business here. So for attending arbitration, that may cause some inconvenience. But here you can see from this table, I gathered the data from the last about 2 weeks time, the number of cases in Hong Kong. You can see there are only a handful of cases in the last 2 weeks, and for local infection, it's getting less and less. And so that's not so much a worry nowadays in Hong Kong. I hope we now are seeing the end of the tunnel. And how to deal with this inconvenience? Now, according to the statistics of HKAC, it hosted a total of 117 hearings in Hong Kong in 2020, and 80 of them were fully or partially virtual. That means the parties, there's no need for them to be physically present in the hearing. Now, it does not affect the seat of the arbitration because the seat, it does not refer to the physical seat of the arbitration. It refers to the location of the arbitration which the parties agree. As long as the parties agree that the seat of arbitration should be deemed to be Hong Kong, no matter where the hearing is taking place, and still the arbitration award is deemed to be rendered in Hong Kong. So this remote hearing can solve a lot of problems caused by the COVID-19 pandemic in the world. So I think most of us, we think there's nothing less convenient to use remote hearing in doing arbitration. They're not inferior to physical face-to-face hearing. And HIAC, they have very up-to-date equipment and facilities for conducting remote hearing. So I think although we have challenges due to this pandemic, but then remote hearing, I think will be the new normal in future in the world in doing arbitration.
Thank you, Kwok. You mentioned the national security law as probably one of passing of this law can be concern probably to Russian parties. So can you please address this issue regarding the national security law in more detail, please?
Yes. Now, national security law, some people may think it's the sensitive subject which should not touch on, but actually it's part of Hong Kong law, so there's no way we can avoid national security law in Hong Kong. But I think my personal opinion is that there's nothing to do with civil justice, including arbitration. Now, today, of course, it's not the place to discuss the contents of this national security law, but here I set out the offenses under this piece of law, and you can see it mainly deals with the subverting the state power. So I cannot imagine how arbitration has anything to do with subverting the state power. You can see from this PowerPoint, it's talking about overthrowing or undermining the basic system of PRC. We are talking about overthrowing the body of central power of the PRC or the body of power of Hong Kong Special Administrative Region. We are talking about attacking or damaging the premises and facilities used by the body of power of Hong Kong to perform its duties and functions, rendering it incapable of performing its normal duties and functions, and also seriously interfering in or disrupting or undermining the performance of and duties and functions in accordance with law by the body of central power of PRC or the body of power of HKSL, and also any person who incites, assists in, abets or provides pecuniary or other financial assistance or property for the commission of by other persons of this offense. So you can see from this PowerPoint, there's nothing to do with arbitration. So I think that should not be a concern for people coming to Hong Kong to do the arbitration.
Thank you for your response on it. Well, Victoria mentioned that there has been a tiny number of HKC arbitral awards which have been set aside by Hong Kong courts. Well, in order to avoid such a difficulty, you just said that it can be helpful for our participants today to mention what are the grounds for setting aside arbitral awards under Hong Kong law.
Yes. Now, first of all, the approach of the Hong Kong court in arbitration is what we call arbitration biased. That means whenever possible, the court will support arbitration to support the enforcement of the arbitral award rendered by the arbitral tribunals. Now, in order to do that, there's no appeal against an award. We only have some limited grounds for setting aside an award in Hong Kong. Basically, those grounds, they are dealing with the procedural fairness of the award. It mirrors the New York Convention for reciprocal recognition and enforcement of arbitral award. But they're not about enforcement. They are about grounds for setting aside. Now, I list out there are only 8 grounds. Number 1, either the party was under incapacity, or the arbitration agreement is not valid, or not give one of the parties not given proper notice of appointment of arbitrator or arbitration, or one of the parties he or she was unable to present his case properly, or the composition of arbitral authority or arbitral procedure is not in accordance with the agreement of the parties, or the submission of the arbitration is beyond the scope of submission under the arbitration agreement, because in some agreements, not all types of disputes can refer to arbitration. They may limit to a certain a dispute of a certain nature, which is only referable to arbitration, or the subject matter of the arbitration is not capable of settlement by arbitration. For example, matrimonial disputes between the spouse, and or the enforcement of the arbitral award is in conflict with public policy. Now, for example, some the enforcement may result in some immoral implication in Hong Kong. So all these, they are the limited grounds. Only under these circumstances that the party can apply to the Hong Kong court to set aside the award. And also, an application must be made within 3 months after the receipt of the award. Now, this time limit is very strict. If you miss the deadline for even 1 or 2 days, you cannot expect the court to be lenient in your favor. You have to explain with very good reason why you are late in making the application. So this is in support of the what I call the arbitration biased approach of the Hong Kong court.
Thank you for addressing this question. And it's great to hear that there are no specific grounds, only the ones that are mentioned that are provided in the New York Convention. For example, here in Russia, just for your understanding, public policy exception is the main ground for setting aside arbitral awards. And again, like we mentioned, because of the involvement of sanctioned parties, etc., it may create difficulties. But at the same time, as we mentioned, advantages of Hong Kong as a jurisdiction can obviously minimize such risks. And I have another question from you from the audience. During hotel quarantine, members of tribunal and or parties team, upon arriving to Hong Kong for a hearing, can they converse and work together on the case, or are they isolated from each other? Oh, that's actually the question from our moderator, Ilya Nikifor.
Now, in Hong Kong, people cannot gather together in public places. Now, if the parties, they are working as a team with his lawyers, the client, and all experts, they will not do it in public place. So there's no restriction for people more than 4 people in public place to gather together. So there should be no restriction on that.
Okay, great. So I can say that we are just great at timing, because we reserved 1.5 hours of our participants' time and speakers' time for this event. I'd also like to mention that this webinar is being recorded. So to our dear participants, if, for example, your colleagues, because of their busy schedules, were not able to participate online, we'll be able to send you the link to the recording, and with the kind permission of our speakers, share PowerPoints, and in order to demonstrate again HKC as an arbitral institution and Hong Kong as a venue for international arbitration involving Russian parties. And may I ask now to may I ask Ilya Viktorovich, maybe you'll have a closing remark, because as I see, the audience does not have questions. And again, if there will be any, we'll be very grateful for your feedback, and probably there will be questions after the webinar, so we'll be happy to pass them to our speakers lately.
Well, thank you, Ace, for passing the ball back to me. I'm personally excited about what we have heard. Rich presentation, up to the point comments made by the speakers, by Victoria, by Mr. Chung, and of course your starting intervention, Ace. I was all attention during this session. Think it is worthwhile to save us accessible online for future generations. God knows we have many contracts which embody Hong Kong arbitration clause as of now, and in a week's time or in a month's time, somebody may uncover a dispute, may break out, and somebody will need to come back and see these useful materials. Now, in a way of a joke, but still, I was to Australia and I was submitted to 2 weeks hotel quarantine, which was very strict. You could work out of your room, but food you could only take the delivery, not leave your room, sit there for 2 weeks. So by the way of a joke, and in the context of my question, Mr. Chung, apparently in most cases to conduct arbitral proceeding and issue an arbitration award, more than 4 people need to convene. At least this is a tribunal of 3 arbitrators and parties representatives, so more than 4 people. Now, looking at your last slide, which is still on the screen, would such an award be contrary to the public policy in China? Because the convention originally that produced it was more than 4 people.
Well, I have a real example when one of the parties, he's quite evasive to the arbitration, refused to join the hearing because of this restriction, and he threatened to report to police if we do.
Yeah. So such things happen. Such things happen.
Yeah, it happened.
Right. So it's a nice start of a day for us, and a nice end of a day for you in Hong Kong. Thank you all, colleagues, for joining together. Unless our technical assistants see any further questions from the audience on the screen and chat function, then let's conclude. And it's 3 minutes to go yet, but let's save it for 3 minutes. And thank you for being on time. All right, silence. So this concludes our today's session, and let's proceed to our usual business. All right.
Thank you so much.
Thanks everybody for participating.
Thank you. Thank you so much. Bye-bye.
Bye-bye.